Hey everybody, John Skiba here, and in this video I'm going to share with you some tips and strategies that I obtained when I went undercover at a debt collection training seminar. But if this is your first time here to my YouTube channel, go ahead and click subscribe, check on that little bell. That way you'll get notified each and every week when I put out a new video that's going to help you deal with your serious debt problem. Alright, so as a practicing attorney, one thing that I'm required to do, and all attorneys are required to do, is keep up with continuing education classes and hours that we have to do each and every year. Early on in my legal career, I tended to focus on classes that were geared towards consumer attorneys like myself or bankruptcy attorneys like myself that were representing consumers and how to best do that. As I've gone on in the years in my legal career, one thing I've started doing was attending the continuing education classes that are taught by debt collection attorneys. And the reason why is I noticed when I went there, they share all their secrets. And so I know exactly what it is that they're doing and the approach they're taking when they're trying to collect money from my clients. And thus I can adapt my approach and make sure that we're kind of meeting on a level playing field with all of this. So in this video, I wanted to share with you something that I learned recently as I attended a continuing education program put on by some debt collection attorneys. Particularly that's going to be helpful for those of you who are dealing with a default judgment, or maybe they haven't even filed a lawsuit yet. Maybe they're just doing pretty aggressive collections and you're trying to figure out ways to settle it. In this video, I'm going to share with you 5 ways that debt collectors and debt collection law firms are going to try to separate you from your hard-earned money. And if you stick around all the way to the end, I'm going to share with you a sixth tip as far as why it is that debt collectors always seem to show up at the worst possible time. All right, so let's talk about the first one. The first thing that they're going to do, if they have a judgment against you, they filed a lawsuit, they got a default judgment because you didn't respond, or they won at trial, the first thing that they're going to do is they're going to go back and look at their file and their client's file, if it's an attorney, and see what information they already have on you. One of the first areas they're going to look for are things like canceled checks or payments that you have made to like the credit card company in the past. And the reason why they're going to look there first is because they're hoping that you still have a bank account at that particular bank. Then they can levy that account. They can get a writ of garnishment, serve it on the bank, and in most states they're going to be able to take money out of that account to satisfy the judgment. So you need to think back, particularly if your case has been bought by a junk debt buyer. You need to think back to the original creditor and what account were you using to pay that credit card or that medical bill or whatever it is. What were you using to actually pay it off back then? Because that's likely the first place they're going to try to hit is that account. They're going to try to get some kind of levy on there and take that money out, and you won't have any notice of it. So it's important that you look to find out which account you were using and make sure that you don't keep a whole lot of money in there until you get this resolved with the creditor. They're also going to look through the file to determine relatives, contact information, and maybe any other information you had provided them in the past as it relates to assets. They may go back to the application. Sometimes like on personal loans, you're going to have to list certain assets that you may have. They're going to go back and evaluate, based on the information that they already have, is there anything that they can use against you at this point? This brings up the point that I always tell people, when you're talking to these creditors on the phone, don't give them personal information. That information that you're providing them is nothing more than a roadmap to collection once they get a judgment against you. The second thing they're going to do is they're going to conduct an internet search. Now, this seems, obvious that they're going to do this, but they actually go into places that a lot of people don't anticipate. Particularly, they'll go to places like social media. They're going to go there and try to get an idea of what your financial situation is. They're going to see, is this someone who's going on vacation a lot? Is this someone who's showing the brand new car that they got? Or is there job information? When we first signed up for Facebook, we went in there and we were so excited. We filled out all of our occupation, where we live. All of that is not only used by Facebook to market to us, it's used by creditors that can see that information. So something you may want to do is go through and look at your privacy settings on there so that someone who's just doing a random search can't get all of that information, because they absolutely will use it against you. They'll also do a simple asset search. Generally, there's companies out there, LexisNexis is one of them, where they can go in and they can find information about property that you may own, prior addresses, other relatives that they can try to contact, that sort of thing. The third thing they're going to do is a public record search. Now, in every state, there is a portion of the government that maintains public records so that they can be put on, so people can be put on notice if you own a home or if there's a lien on your home. So, for instance, I'm in Arizona. I live in Maricopa County. Maricopa County has a county recorder. And when you buy a house, the recorded deed goes there. If you have things like tax liens, those will be recorded there. They also, most creditors will almost immediately record a judgment once the judgment is obtained. So they'll take that down there, they'll record it, and in certain situations that can act as a lien against any real estate that you have. Well, they will go and look, and usually this is done online. They can look very quickly and see if you have multiple properties. They're also looking for things like, are there tax liens? Because having a tax lien can make their job a little more difficult to collect. So they're going to try to gather information from you through the county recorder. If you want to see what they're going to see, you can usually go online to your local county recorder, type your name in, and you're going to see all the documentation that's out there that they're going to be looking at. The fourth thing that they can do is hire a private investigator. When I was a young attorney, I didn't think that this was true, that they would actually, it sounded like something off of a movie, but it is something that they do, particularly if you're dealing with large debts, large judgments, and particularly if you are a business owner or a person who has a fair amount of assets. They can hire private investigators who can do a lot of digging. One thing that they do is they tend to hire private investigators to find bank account information. Bank account information is not readily available online. If they do one of these simple background checks, they're not going to see that you have a checking account at Wells Fargo or Chase Bank, and they're not going to be able to get the account numbers. That information, thankfully, is fairly private. However, these private investigators can often go out and find additional information through other methods. What those other methods are, I've heard collection attorneys say, I don't want to know what those other methods are, because somehow they get that information and take that back to the attorney, who will then try to garnish your wages or garnish your bank account. They also may be following someone to see where they work so that they can do the same thing, hit them with a wage garnishment. So private investigators, I don't tend to see it like on a lot of junk debt buyer cases, but if there's a large judgment that's out there, absolutely, I've seen it, where they'll try to follow a person to get information to be able to satisfy that judgment. Next thing is post-judgment discovery. Just because you went through the court process and a judgment was entered and trial is over, that doesn't mean that the court doesn't still have some authority to help the creditor get information from you. They can actually send over interrogatories and requests for production of documents after the trial is entered, requesting a whole lot more information than they did or that they were allowed to request before the judgment was entered. They can ask for information on your bank statements, for tax returns, pay records. They can get almost everything. It's pretty much an open book. A common approach too in post-judgment discovery are things called judgment debtor exams, where they actually bring you into the courthouse or they bring you into a law office, and you're required to testify under oath where this information is, what your assets are, how much you make, where you bank, all that kind of information. And I always tell people, you got to be really careful with judgment debtors exams, because usually the court's going to issue a subpoena for you to show up and participate in that process. And if you don't, in states like Arizona, the court can actually issue a contempt order against you, as well as what's called a civil arrest warrant, meaning that if you're out driving around and you get pulled over for speeding, that's going to pop up. The police officer is going to take you into custody over this debt. It's one of the few times when you could actually go to jail for not paying a debt is in connection with a judgment debtors exam. So you've got to be really careful there. So those are some of the ways that they're going to try to find information about you so that they can get money from you. You can use that to your benefit by understanding what it is that they're seeing. And then when you go approach them with a settlement proposal, so that you hopefully avoid all of those problems, that you're doing it with what they're looking at in mind. And what I mean by that is, let's say that you're a person who you have your home and you have a rental property, you have several vehicles, maybe you have like a boat or something like that that's paid for. And let's say that you're also putting that on social media all the time, like we all do. If you go to them and offer some real lowball settlement offer, like some 5% settlement offer, they're probably not going to take it because they are seeing from the outside that you have significant assets. They may have information on where you're employed. All of those things come together, and they're thinking, hey, we're not going to take something that low. And so that you need to kind of tailor your settlement approach to what it is that you're anticipating that they're seeing. That doesn't mean you got to come in there with a full offer, or they're going to even require a full offer, but you can't lowball them if there's a ton of assets out there. The opposite is also true. If everything is a complete mess right now, if you have tax liens, if you have other judgments that are recorded against you, if there's other creditors that are suing you, maybe if you've had a recent bankruptcy, if it just looks like things are kind of chaotic right now, or you're not employed, maybe you don't have a bank account, all those things tell a creditor, hey, this person's going to be much more difficult to collect from, and so maybe we should take a lower offer and just get what we can get at this point. So you can kind of use that to your benefit both ways. So before we wrap up, let me share with you the 6 tip that I talked about as far as why it is that debt collectors and attorneys, they always seem to show up at the worst possible time. Not that there's a good time for them to show up. But it always seems like, hey, I'm buying a house or I just bought a car, and then all of a sudden here comes all these creditors. And the reason is because the main 3 credit reporting agencies, TransUnion, Equifax, and Experian, they sell to creditors and creditors' attorneys things called trigger reports. They're collecting all this information about you and your credit report, and when something changes, it triggers them sending the collector a letter saying, hey, John just bought a new house, or John just bought a new car, and we know that because there's a new account on his credit report. There's been a change. Well, a change oftentimes means to a collector, there's something going on here where maybe you're in a better position than you were 3 years ago when they sued you. They may have sued you, got a default judgment, haven't collected anything, but now they're seeing that you had enough money to buy a house, maybe put a down payment down. They're equating that maybe that means that you have a job. They also know that it puts a lot of pressure on you if all of a sudden you're trying to close on a house or sell a house, and they show up with a judgment that they're wanting to be paid on. So those trigger reports are things that they're real. The credit reporting agencies, those are private companies. Sometimes I run into people who think that TransUnion, Equifax, and Experian are part of the government. They're not. They're just private companies out there to sell your information to other parties, and they do. So they sell anytime there's a big change, they notify the collector, and that's why they seem to show up. It's not always just a horrible coincidence. It's just horrible. I hope that's helpful as you are trying to deal with your creditors and trying to settle these debts. And I appreciate you watching today. We'll catch you later.